Good evening, ladies and gentlemen. I'd like to call the meeting to order, please. I'd ask you to rise and salute the flag. Pledge allegiance
to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Would you remain standing for just one moment as we say a prayer for the victims of 9/11, please? Thank you. Gee, may I have roll call, please?
Chairperson Cleaver.
Here.
Dickinson.
Here.
Bushian. Chowski.
Here.
Fullerton.
Here.
Walperly.
Here.
Gunn. Calvadas.
Here.
Kapadas. David Rowan.
Here.
And John Pettit.
Here.
Keith Knight.
Here.
Let's at least make sure we do roll call with the alternates. We want to include them in roll call, even if they're not going to, we're not going to include them in a roll call for votes when they're not eligible to vote, but they should be included in the roll call of the meeting itself.
Beatrice is not here and Bill Over is
Yep.
absent.
Thank you. Public notice of this meeting pursuant to the Open Public Meeting Act has been given by the clerk in the following manner: posted on the bulletin board in the Borough Clerk's office, emailed to the retrospect and the Courier Post. I'll entertain a motion to approve the minutes of the August 14th meeting. Debbie and Mr. Dickinson, is there any questions on the minutes? All in favor? Under new business, Mr. Raymond, would you like to read the resolution memorializing a minor subdivision for the Butler Group?
Yes, we have one resolution to act on tonight regarding premises located at 827 East Deepsham Avenue, block 149.06, lot 2. It's a residential zone. A minor subdivision came before us at our latest meeting, wherein a piece of block 149.06, lot 2 is to be subdivided and consolidated with block 149.01, lot 1. As the board may recall, the board acted favorably on the minor subdivision. There appeared to be no objection from the public, and the resolution is, the approval was, or the subdivision was approved, conditioned that the applicant would obtain and receive any and all other state, county, or local approvals which may be required.
Is there any questions on the resolution from members of the board? Okay, motion's been made by Mr. Dickinson, is there a second? Second. Motion made by Mr. Dickinson, second by Mayor Calvadas to adopt the resolution as read. May I have roll call, please?
Cleaver.
Yes.
Dickinson.
Yes.
Bushian.
Yes.
Chowski.
Yes.
Fullerton.
Abstain.
Walperly.
Abstain.
Gunn is absent. Calvadas.
Yes.
Kapadas is absent, and the two alternates absent.
Okay. Consider the resolution adopted as read. Do you have anything under old business we need to go over? At this point in time, I don't know if everyone is aware, but there's a possibility that next month we will be hearing on a density variance for the Butler Group application. We obviously don't have the agenda for next month, but in the time that I've been up here for 15 years, I've never acted on a density variance. So I asked Mr. Rowan to review some case law for us and go over the criteria for a density variance so that we are, ready for the client when they come in to give the applicant, all their due as far as what is required, what the criteria is. So, Mr. Rowan, we just, I'll defer to you, just go over it quickly.
Yeah, thank you.
Yeah.
I passed out to everybody a copy of the case known as Grubbs versus Slot Tower and the Rahway Zoning Board of Adjustment. This was a matter that went up to the appellate division and was specifically focused on density variances. Before this case was written and became law, there was a companion case, I believe, called Country Square versus the Westwood Zoning Board of Adjustment. That case took in consideration what has to be proved or what a board has to present when they're giving a variance regarding area restrictions, like how many square feet to a house, et cetera, what you can build. The Grubbs case, the judges in that case said that density variances are not the same as use variances. And the burden of proofs and the standards of proof that an applicant have to meet are different than a use variance. A use variance is what the court opined is brought before a board because that use is not permitted in a particular zone. There's a prohibition. Density cases or density use variances, the density is not prohibited, it's just a density number that's set forth in a zoning ordinance. So the court said you don't have to prove one of the main things that you would have to prove on a use variance, that there's a special reason why it should be granted. Now, this case, the Grubbs case, sets down, and I picked out a couple of the salient points. It's not a long opinion, but it is the opinion that now guides both applicants and boards in rendering a decision. And what this court says is that planning boards must relax the standard of review, which will be applied for variance applications seeking deviations from density requirements. All right, so relaxing means that the applicant doesn't have as great a burden as he would under a regular use variance. And that a density variance is seeking a departure from certain regulation applicable to a use the municipality has chosen to permit, not prohibit. In other words, if you're permitting a certain zone to have construction, whether it's single family or multifamily or townhouse sort of development, you're allowing that, and you set up certain density requirements, but it is not the use itself that the density variance is going to apply to is not prohibited in that zone. So the applicant, when they come before a board, they don't have to prove that that property is particularly designed or particularly suitable for the use they're intending to make, vis-a-vis either multifamily housing or single-family housing. They don't have to do that. What they have to show to a board is that the increase in density is not going to cause, is not, the site itself is going to accommodate any problems or any negatives that would be connected with the proposed enhanced density. In other words, the board has to look at it, well, what about traffic patterns? Okay, what about the facilities that are already at the site? What about possibility of open space? Okay, our ordinance addresses that, although the townhouse type of building is permitted in Zone 3, it's also in connection with open space. So that would have to be a question that would have to be answered. If there's any other facilities that are serving that lot, in other words, is there sufficient egress or ingress? I have to repeat myself, but what traffic patterns are there going to be problems created by an enhanced density use? The applicant still has to prove that there's no negative effect to surrounding and adjacent neighborhoods or adjacent properties. Okay, they still have to prove that. You have to be satisfied with that. The applicant also has to prove that their request is not substantially inconsistent with the requirements of our zoning ordinance.
Okay.
It's kind of the court doesn't give a clear, in fact, if you read the case, the last page, the judges state that, look, we're not giving you an exhaustive instruction here. I mean, we're leaving it up to you to make a decision, but if the property, the site itself can be utilized with a greater density, you have to really take a look at it. You may have to approve it if the applicant's successful in showing you that the increase in density is not creating any problems which may not already be associated with the problem.
Now, how would we go about it, say, if we heard testimony and whatnot, and, some of the board members or the professionals decided that, listen, it might be okay to increase the density, but not to the amount of whatever would be on a particular application? How can we go about saying, okay, we're going to allow you to increase the density, but we really, our plan online, when we reviewed the master plan, was to afford a lot more open space than what this density variance will allow, but we are open to perhaps allowing, some increase in the density variance, but not to this extent. Can we grant a portion of density variance increase?
Well, you would have to be satisfied that what proofs any applicant's bringing you, okay, is going to satisfy your concern. You couldn't say, well, we're not agreeing with what you're proposing, but we will agree to this. You would have to give them a reason, that's a credible reason of why you would deny the increased density that they're requesting.
So basically, if an applicant were to come in here and request the density variance, and we would have to say all or nothing. It would basically be all or nothing. We couldn't say,
They can always amend their application.
they'd have to come back, or could they amend it?
They could amend it that night.
They could amend it that.
If the board said, we don't think the density of 5 per acre is appropriate, but 4 might be
Right.
more palatable based
Right.
on the traffic conditions.
Yeah,
We
we have
could
a,
amend it that evening and say, we'll submit revised plan.
But your opinion or your decision has to be based on something, not just, well, I personally feel that
Sure.
I don't like townhouses.
No,
That
no.
would be capricious.
I'm just thinking about the open space issues,
Right,
about.
yeah, they're all the issues that you would have to allow them to give testimony to.
Right.
And any applicant come and hear their testimony, and then the board, based on, I guess, on John's review,
I just wanted to know whether it was an all or nothing thing, because I don't think we need to draw a line in the sand. I think we need to hear whatever the applicant might be.
I have one question about the basic ownership of the land. It appears to me,
We're not talking about any particular applicant right now.
about an application.
Yeah, we're not talking
no,
about.
we're not talking about the application that might come
If
before.
the applicant has preliminary approval and they sell their interest before final approval, the municipality is entitled to injunctive relief, and it's right in land use law.
I don't know if I'm following you, Dick.
Okay, selling before approval, penalty suits by municipalities. This is the third iteration,
Third what?
third time we've looked at this piece of land.
An applicant, there could be many applications on one piece of ground.
Okay?
You can't
Once
stop.
they have approval, that's what the land's approved for,
To that
for
applicant.
single-family homes.
But if-
To that applicant.
Only to that applicant, or if he sells that.
If he sells it, the law says we're entitled to injunctive relief.
But he doesn't have to build it, Dick. Another person could come in with another application for something, all you gotta do. Somebody could come in and say they want to put assisted living building here.
But
In other words, an applicant, the ground is not then restricted to what your approval is. In other words, the prior approval that you may have given regarding a particular site doesn't go with it affects the
The
ground.
approval goes with the land.
Yeah, but
But it doesn't restrict it.
it doesn't restrict the land. It goes with the land, yes.
The law doesn't say that.
It does not restrict the land.
Like we approved the bank on for the corner where the plan used to be, we approved the bank, and then when they came back in, decided they would do Med Express.
Perfect example. When the bank wanted to build here, they had to live up to everything that we had previously approved as far as footprint went, setbacks, driveways, ingress, egress, everything.
That
We
was
already
an
did that.
amended plan. That was an amended plan.
Yeah, they
What if
came,
Wawa had wanted to come in and say, we don't want to put a bank there, we want to be heard all together, we want to have a bank, and we want to have.
No, I think we're mixing apples and oranges
No,
here.
no. They're not prohibited from bringing another application.
But they're not prohibited from selling the regular land either. Once there's
So they can sell
approval.
the grant to whoever they want, sir.
I don't know, I think
Yeah,
if
I'm
the
trying-
municipality challenges, I think they get win.
Now, you win-win. I'm sorry, I mean, that's my opinion, but you win-win.
well, like I said, I don't think as a board, anybody up here is looking to draw a line in the sand. We want what's best for the town and the applicant first and foremost. I think we want to make something that's palatable for everybody, at least I do. I want it to be palatable for everyone. And I didn't want to, not have something to, base our decision upon. And it sounds to me like, I think what we've talked about in the past, the open space is going to probably be our number one issue that we certainly, when we redid the master plan, we certainly talked about that an awful lot. Even when Bobby Williamson was up there, Chairman, we talked about that. We beat that till it was dead, that we wanted to keep some open space back there. But there's not many places to keep open space, so that's a big thing that we're gonna, I think, need to address. The ingress, I guess, good to see the plan and defer to you as far as what your opinion is.
I think the roadway system, if we're talking about a particular application, is identical to what was approved for the single family homes.
Okay?
The other problem though that the board's going to have to deal with is there's going to be numerous variances, bulk variances, for lot size, lot width, setbacks. Because there's no standards in the ordinance for this type of a development.
And I think if we are going to, go forward with the, whatever application might come in front of us, I think we have to determine if we have to go slow and do it in stages. I think if anybody's going to come in and develop any large piece of property, any large parcel in Runnymede, there's not many of them left. I think we need to examine it very closely. And if it takes us 4 months to go through it and do it step by step properly, I want to give every advantage to the applicant that they deserve, and I want to give, proper credence to what we're supposed to be doing up here.
Well, the code at present is silent to density.
Now, it's 3 per acre, Dick. That's what our code says.
In the case of an applicant coming before the board, and we had some concerns, say, about the impact on traffic or something, I know the burden of proof would be on the applicant to show that there's no negative impact, but are they then required to do their own traffic study, or is that something that
Well,
they did?
Yeah,
I don't want to get too particular on this application,
Right.
but usually when somebody comes in for a density variance, they do a traffic impact study. And then the town's engineer can then look at that. A board can then look at that and say, well, we're not satisfied, or we have a concern. Your approval is based on that the board would be satisfied with the proofs that were elicited, that an increase in density is not going to create any problems that can't be remedied.
But the board wouldn't be under any obligation to take their study as fact. We wouldn't have to take that at face value.
You have to take it as, you have to take it under advisement. Now, if we didn't have our own study, typically when let's go beyond a regular board going to litigation. If somebody goes before a judge and one person has a doctor's report and the other person doesn't, well, then the court only has one report to look at. Okay. So, based on, John,
Well, typically in this type of an application, the applicant will bring a traffic engineer to address the board and present their findings. And then you have the right to question. You know,
We already have a
if you
traffic
think-
study done.
You think that the level of service at a certain intersection, they're saying.
we're
is
talking
a
about certain stage, and we say, I can't really
There's
go
no
left.
left, you know, and we think there's gonna be an impact. But, you know, correct me if I'm wrong, I think the only thing you can judge the application on is the impact, the additional traffic, not
Right.
the existing traffic.
Of course.
At an intersection.
Yeah, I think the low density, thing is, like you said, it's just based upon how it's gonna change the existing site. If you're, all right, let's, that's really all I had as far as.
And then, if you read this case, the appellate division says, they talk about an applicant demonstrating the likelihood that a minimal increase in density is going to negatively impact the lane. Well, then you have to determine, well, is this what what an applicant's asking for? Is that a minimal increase or is it a significant increase? If a board determines that it's a significant increase, you might want more proofs to assuage your concerns that there's more of a negative impact than there would be a positive impact. So there are things that you have to consider. But the case also goes on is they're not telling, and if you read it, they're not telling a board what to do. They're just giving you guidelines. Obviously a board is the final arbiter. Now that decision can be appealed to either the town council or it could be appealed to have a superior court judge look at it and make findings and then possibly send it back to the board and say, well, board, look, you did fine, but I want you to re-examine these 3 issues or this 1 issue.
So is the trial judge's decision because they did not even require a density variance in the first place?
No, what happened, Deborah, the density and floor area variances were held to a higher proof. The leading case for, they were considering it almost like a density variance and a floor area variance like a use variance. And use variances, the applicant's requirements there come under a case named the DC. And the DC made it almost impossible. You had to show that this property couldn't be used for any other, that it was suited for this particular use.
That's for use variance.
Use variance. Well, the courts in Grubb and Coventry was the one that case that dealt with floor areas. Grubb is particularly density variances. They're saying, no, board, you don't have to be that stringent with an applicant. You got to relax it a little bit. Let them try to prove that by them increasing the density on a particular ground, that any of the problems that might arise regarding utilities, lines, sidewalks, traffic patterns, that they can be remedied where there won't be a negative impact. If they can do that, board, you may have to grant them their approval. If you're not satisfied that they're able to do that, then you can say, well, we're not, it's too much of an impact. We're not going to approve that density development. But we'll always look at maybe an alternative.
Now, at that point, Mr. Rowan, would the application stop until they came back? Say an applicant came before us and they had a plan in front of us that we thought was, too much of an increase in density. If they don't get their approval for the density variance that would be needed to approve their application, would that application then stop?
Yeah,
In other words, if you don't get the use variance,
Right? What's that?
They would be denied.
Yeah.
Yeah,
If you don't get the-
you're right. I think you're amended, yeah.
right, so in other words, what I'm saying is, if someone comes in and they need a use variance to put up a tattoo parlor where there is a store,
Right,
if we don't grant the use variance, then the application stops.
right. Think that since we're a joint board, the density variance would come before the zoning board. Okay? So typically, the zoning board would act on it. If they act favorably, then the site plan would go to the planning board. We're a combined.
Right. The site plan won't even be heard, basically, if density variance isn't approved. At that point in time, that application stops, and we do not hear the site plan as if it were a use variance.
I think as the chair, the board would probably say to an applicant, we would like to hear your proofs on your density variance first. Wouldn't you agree, John, before we go? Because you don't want to have, and because the other thing is,
That's what I'm thinking,
the
yeah.
mayor and Nick can't hear a density
Right,
variance.
so they can hear the application.
That, once that's cleared, yeah, they, you know, they could.
Yep, okay. Just wanted to make sure.
Yeah.
Punch back room again.
Question, I've seen many plans for different townhouses. Now, if they want to put 6 or 8 townhouses in like building A, and building B only wants to put 4, and building, how does that how does that get calculated?
It's the, in total.
So
It's, yeah, it's
three out, three per,
three per,
3,000,
3 per acre.
650
You
square
count the
feet.
total number of units, you take the total acreage and divide it by the total number of units proposed. And that's the density, that's the number of units per acre. Your ordinance permits 3 units per acre.
Okay, does anybody remember how many acres we have here?
What was it, 19, or was it more?
15. I believe, I thought there were like 5 or 6 units per acre.
Is that density applied to single family also?
Yes, yeah.
And we've already agreed, with 80-foot front, that, you know,
They didn't need
the
a
building's more than 3
density.
units per acre,
That
because
was
it's
They were
240
okay with the
foot.
density.
They were okay with the density.
With the single family.
They accepted that, right? And we granted that.
Yeah, yes.
Oh, okay.
What you got, Mr. Overland?
Are we allowed to take into consideration the impact that could possibly have with schools?
You can request that. Then there usually, you can ask about that, but without knowing what our census is at the schools, you know, what the impact's gonna be.
How can we find that
It's
out?
for a fiscal impact study.
Yeah, I mean, you may be able to do that, absolutely sure.
Well, I know the schools have a problem fitting pre-K in when they made that mandatory in the state.
Yeah, I mean, there are
That
all
was a
things
big
that you
problem
have
for
to,
remedy.
you know, that you got a question. You know, absolutely.
So at that point in time, an applicant could.
Now, if they were able
come
to
back.
satisfy that, if sometimes a lot of applicants will do their homework and they'll have a school census, and when that issue is brought up, then they said, well, here we have the census, it will have no impact. Now, they've just fortified their application. In other words, they strengthened their application, because now that's another thing, well, fiscally, it might not be an impact.
Do you think the courts would be amenable to a suggestion that Runnymede is a host community for one of the schools of Black Forest Pike Regional? And that 9 months during the year, that our streets are traveled more than the other ones that aren't?
Yeah, Dick, I don't know if that, you know, that, and there is also instances with fiscal impacts, people say, well, what's that going to do with our schools? There's certain, I remember a case law that said, well, look, town, you're permitting building, okay, so you've got to assume that there's going to be, any building is going to be an impact. So it minimizes that, you know, that possibility of the argument that it's going to may increase, you know.
And they,
That would be a better argument if townhomes weren't permitted in zone.
Right.
They're asking for a use variance.
Right,
Right.
but they're not, they are.
That don't really fail.
They
I think
are.
it may be something that's gonna be deed restricted, we don't know that. So
Yeah, we don't know what,
It
I
could
mean,
be,
it doesn't.
an applicant could come in and do a deed restricted,
Yeah, I mean, you have to hear testimony that what the size of their building, you know, you have to, but you wouldn't do that as a precursor, I would maybe
Well-
ask to see what they intend to build, so at least you.
My understanding I'm sorry, I didn't mean to interrupt you. I have to think, well, second,
I do it all the time.
that board of adjustment, right, and a planning board. Planning board is a body of approved uses, right?
Right.
The zoning board of adjustment is approved of, is a function of not permitted uses
Or D variances.
or variance.
Or.
Is it a C
density
variance or D
Height
variance?
variances, excuse
It's a
me?
D.
Is it D variance?
Is in dog.
Yeah, D.
As in density.
Density, building height, use,
Right.
those are specific variances set forth in the variance law.
Planning
That
boards
only
can,
the zoning board can grant.
right. Planning boards can do any bulk variances. Anything with side yards, the size of the lot, depth, things like that.
No, but it's a permitted use too, right?
What's that?
It's defined in the permitted uses.
It's absolutely, it's defined as permitted use.
Oh, anyone else have any questions? I mean, I appreciate you taking the time to,
But we are read the case.
Absolutely.
It's not, it says that the planning board shall, doesn't say you must, but it does say you've got to relax the rules.
Mhm.
Because you're already saying development can be there, so it's not that
Right.
they're asking for a use variance. But they have to satisfy you that any increase in density, or even if it was floor area, that's going to be conducive, that lot can handle that. And the physical aspects of the lot, the off-site improvements, the traffic patterns,
I know you've been doing this business, in this business for a long time, Mr. Rowan. How about parking?
parking, where you have to sit, review to see if it's going to be off-street or on-street.
If the RSIS said they need 3 places per unit, and they're only providing 2.3 or 2.4,
That would be,
That's-
there would be another variance.
That would be a reason to say the
well,
density is too
what would you
much.
say, it's supposed their deficiency is in excess of 20% with providing parking spaces. You think that's a valid cause? You're not voting.
No, you're voting, the board would have to.
I'm just
that, yeah.
asking some questions
Yeah,
because
I mean, that's
I
what the board would have to.
think there's very good
But
deficiency.
remember, and when you do decide, and maybe if you're going to look at an application maybe unfavorably, you have to give a reason. Yeah, you have to be a reason, well, this is why we don't think it's, and you just, either one of you or all of you can concur, and yeah, that's our concern, or, that hasn't been proven, and that's what we're.
what can we do? What can we do to bring this application up to snuff
Right.
where,
Right.
we have parity amongst,
Yeah, no, absolutely.
that's just my opinion, I think, we have to try to make every application that comes before us, whether it's for a
Absolutely.
popsicle stand, no matter what it's
As
for.
long as they want, and of course, the public has the right to question an applicant.
Any other questions, Mr. Rohan or Mr. Pettit?
I'm just wondering, because we don't have any ordinances right now specifying
Standards?
standards, for
Well,
townhomes, say
well-
an applicant was to come before us.
Well, what an applicant would do, if I was representing this applicant, I would look at the standards that we do have in an ordinance. So the first one I would look at, well, obviously, is the density, 3 per acre. Then I would go down, well, minimum lot size, 8,000 feet.
Would that apply to a townhome? even
Yeah,
though-
they would have to get a variance from that,
For every lot,
for every lot.
pretty much every lot.
So even though there may not be something specifically on our ordinances regarding an attached group of homes,
Right.
they would have to first meet the ordinances, the standards of a detached home.
Basically, yeah, that would be.
Okay.
Now, if we came down to say, a minimum lot width, 80 feet, well, we're asking for a variance, we want 30 feet.
Without the board granting a variance, those are the controls that have to be true.
So it wouldn't be an instance where theoretically, if an applicant were to come in and say, because we didn't have standards on the books regarding attached homes, they don't even have to come before us. That's still.
Oh,
in
absolutely.
your day.
Approval, yes.
Yeah, absolutely.
What was the things I put out there?
Just want to make sure that they, it wouldn't be a case theoretically, because we don't have anything specifically on our books regarding standards for townhomes, that wouldn't make an applicant decide that they really didn't have to come before us at all because there's no variance involved. We're
Right.
still, okay, all right.
There are townhouses around Kimberly Drive. It's a horseshoe. I don't know how many back in there, 20 or 30.
Well, I feel better if we were to come across the density variance in the near future. I think I'd feel better if I feel that I'm a little bit more educated myself as to the criteria for approving it. You know, like I said, I think we have to put the best plan forward for the town and for whatever applicant were to come in front of us.
An applicant has to convince you folks. But if their proofs are sufficient, if they're reasonable and logical, and you feel that they have either eliminated or minimized any impact or problems that they satisfy you that there won't be a problem, then this Grubb case says, well, board, you may have to act favorably. If all other conditions and everything else, they can satisfy you, and then you're accepting, their proofs, and you're comfortable with that. You can't, if an applicant comes in or a member of the public, a lot of times they say, well, it's cool, you hear, a lot of times, even if somebody's building a garage, well, it's going to devaluate my property. Well, you really can't, you can hear it, but you can't consider that unless there's expert proof that that's going to happen. Okay, so,
Is there any burden on an applicant to show hardship regarding any of this? When
no, hardship, yeah.
Like
no,
this,
hardship.
what's on-
Hardships never usually, variances come in, they're usually C variances, because the ground is such a certain way, remember, we've had pieces of, remember people come in there want to triangle, they want to widen their house, well, that's a hardship, they want the lots the way it is. Now, if they had created that lot themselves by a subdivision, well, then you can't benefit by a self-imposed hardship, created hardship. But no, they don't have to show a hardship.
They would have to show that there was no other use for a particular property other than what they're proposing, I guess. right?
Well, no, that's under the Dici case.
Okay.
Under this, they don't, under Grubb's saying, hey, they don't have to prove that anymore. Because it's not a use variance.
What
It's a
about,
density variance.
what about impact on our resources?
Absolutely.
For our police force, our fire department, or things of that nature.
Yeah, they're all things that have to, be considered and addressed.
Might negate us being able to handle the municipal waste there.
Dick, you don't know, I mean, that's an approval, they would have to, there's no sewer back there, right? They have to pump into,
Yeah, there's sewer back there.
the sewer all back into that line? Oh.
They were proposing public sewer.
Oh, it isn't there now, they have to put it in, right?
Yeah, they would
Yeah,
extend,
extend
gravity
it.
lines.
Is there enough capacity? I mean, that's,
Pipe this big or pipe this big?
The lines are there.
If the board were
You're going to
to,
drive through or when you going to walk through?
if the board were to approve the subdivision and the density variance, and there's no capacity, they can't build it anyway.
right, they can't build.
So that's an outside agency approval that they have to
Okay.
get. Same thing with water.
Right.
They have to-
Yeah, I'm gonna presume any approval.
Yeah, I figured that much. I was just-
Even previous approvals that we've granted, and they might
Right.
get a pumping station,
How about artillery?
or something.
Yeah, no, I assumed that would be an outside agency, but I'm just concerned about like the police force, fire department.
Those have an impact, but it's hard to quantify. Yeah, the courts really don't put a lot of weight on that to support a township or a borough from denying an application. Because they're gonna say, well, folks, you're allowing people to build anyway, you know it's gonna have an impact. You can't, towns, you
Usually
can't,
it's gonna pay taxes.
yeah, and they can't stay stagnant. It's just like, in over 55 that don't have kids. There was, when they first started, the argument was, well, why taxes we're not impacting your schools, we shouldn't pay school tax. It just wasn't that way.
Right.
Wish there was.
All right, well, I thank you for that. Under communications, if we're all through with the density variance communication, under other communications, we have something from Wawa that I received. John, do you want to comment on that?
Yes, we received correspondence and a plan from Prime Law Group. The plan was prepared by Bowler for the existing Wawa in town. What they're looking to do is make a modification to allow the sale of diesel gasoline. There's really not going to be any changes to the site that anyone will notice other than a new dispenser for the diesel fuel and modifications to the existing signage. But the size of the sign isn't changing, just the faceplate. So they're asking for administrative approval. I'm not even sure that they need site plan
Yeah.
approval to do it, so.
It was a kind of a courtesy when I read
Yeah,
it. It
you know,
appeared,
they called me and I said, yes, send it in.
yeah, it appeared to be a courtesy.
You know, in the correspondence, they said, and I think everybody understands, it's not going to be for tractor trailers that can get through that site.
Semi.
It's for,
Since I had no turn radius
no,
there.
you're not getting through. This is for the newer cars, the clean burning diesel cars.
They have one further down the pike, because I pulled up to that pump on mistake the other day. And I said, Steve.
I said, Mr. Weather, do
I've been
we-
backing into the shop, they already have the diesel tank in the ground or what?
No, they're going to put a new tank in the ground. Obviously, new connections to dispensing. Like I said, you know, at the end of the day, no one's going to notice there's any changes at all, other than there's going to be
Is
green.
diesel fuel more volatile than regular?
I think it's less.
Less.
actually.
Less. Okay, so Mr. Weather, do we need to act on this
I mean,
administratively?
yeah, we could do a resolution and say we're going to do an administrative of, I would, since I think their letter did say, John,
I have a copy here. Do you-
there's no no tractor refill. You know, maybe we should quantify the administrative approval resolution by saying it's understood that there's not going to be any.
My question is, if they're going to have no semi-traffic, there's no signage there that says no semi-traffic.
Well, I don't think any truck driver.
There's no, I don't think trucks going to go in there.
I mean, we could put that in.
Until the guy bumps up in there and runs into somebody and we have a major fire.
Do you-
But I don't
do you
think no
copy this?
signs out on the highway saying the truck either. 'cause that-
You know what I'll probably need,
It's more signage.
June, if you can find the original resolution for this, if we do the administrative resolution, we should refer back to when they were approved. You think we have that?
I probably have it, but Jim doesn't.
Some kind of year with.
Well, any date that you would give me, I'll believe you.
It was 2001, I believe, but.
You know what I'll do? I'm gonna call Duncan at Prime, that must be.
2001, right off.
And I'm sure they have it. But you wanna vote on that resolution? I mean, just,
Well,
or should we just give them a letter? I mean, I can give them a letter that.
I think we should vote on a resolution. I mean, if somebody has a concern, I mean, you know, we're here, we can certainly, if you want to verbally read a resolution, and we'll vote on it, we'll memorialize it next meeting.
All right, then
We'll
I
send
would
the letter.
suggest, okay, and I would suggest that, let me do a resolution and, for administrative amendment, but put in here that since they're saying anything, they're not going to sell to tractor trailers as part of this diesel
It's
distribution.
a condition of our amendment.
Yeah.
If we're going to do that, we ought to notify the fire department, figure out how to have a different mixture there.
Well, I think they're going to have to do an inspection anyway.
Yeah.
Once they put that new tank in there.
Freddie will be there.
Yeah. All right, I'll do a resolution.
Okay, so do you want to do that next meeting?
Yeah, I'll just, and then you can just vote on the resolution. at the next meeting.
All right, so, John, do you need to do anything? I know they sent you plans as a courtesy, pretty much. Let's see. similar planning in a changing environment. June, do you have information on that?
Not with me. It's
Okay.
in the office if anybody wants to attend it.
Okay. You'll probably do what the dates are, or?
I'm not doing it. Is anybody interested in going first before
When, with the,
I'm not doing it?
That's 31 days, Ms. Hopkins. We gotta be more specific, I can't take the whole month of October off. All right. Is anybody interested, June, could communicate to you?
What was it called?
Seminar planning, it's ANJEC, seminar planning in a changing environment. I'm assuming it's probably renewable energy and things of that nature?
Yeah.
Where is it?
Somewhere, sometime in October.
It's sometime in October, it's somewhere in the state of New Jersey, Pennsylvania, or Delaware.
I was going to
Transportation
the same
provided?
thing. We'll stop together. If you're interested, I'll make sure we can get you to.
Yeah, why don't we just send out an email to all the members? Is there a cost involved? Is there a cost? Okay.
Is it something that you think one of us should look into, or, you know, you can let us know, or based on, we don't really know what the specifics are.
Right,
You can see me after the meeting.
okay, thank you. All right. Anybody else have anything before we go into good welfare? All right, well, at this time, I'd like to open the meeting to the public. Anyone wishing to speak on any matter, please come forward and be heard.
Seeing no one, I move that the good welfare portion.
All right, all right, we have a motion by Sis, seconded by Scott, to close the public portion of the meeting. All in favor? Okay, Mr. Knight, did you have anything you'd like to go over with us, sir?
I have no report unless you have anything for me, Chair.
Okay, no, the only thing, I don't know if you've been, why don't you come up for a second?
Sure.
Please. I thought Dean from the Vault was going to come in tonight. He was out in the hall with Mr. Mecca. I understand he had a conversation with you regarding there not being an ordinance, you know, for having the concrete enclosure that we put on his site plan. Just for everyone's edification, I did send an email to him, I guess it was back in August, John, that, you know, the wood fence that he has up there is not, you know, what was on his site plan, and that he would not be able to deviate from that, you know, unless, you know, he would be granted permission from this board. And out in the hallway, he was talking to Mr. Mecca about an extension, and, you know, we made it quite clear that nobody could really do anything as far as changes to his site plan without it coming back before this board. So if you see that it is not done, I think Mr. Mecca was speaking to him about granting him some type of an extension. That's certainly within Mr. Mecca's purview if he sees fit to do that. And I know we did do that for the old CVS property. They wanted to defer on the bulk of the landscaping because they wanted to do a two-stage thing where they did all the concrete work and the pavement work in the fall, and they wanted to defer on all of the landscape architecture until the spring for monetary reasons. And I do recall that we did allow that, but he was certainly not told that by anybody on this board. It's certainly Mr. Mecca's call at this point in time. And my communication in my email was that pretty much every business that's come before us in recent history that I know of, especially a restaurant, has been asked to, you know, erect a concrete enclosure. So if you do see the fence up there, I'm assuming Mr. Mecca and Dean spoke and they arrived at a decision to grant an extension. But this board does not grant extensions. You know, that's something Mr. Mecca does, and it's one of, he wants a site plan approval, he has to come back before us. And I know he asked you to find if there was an ordinance, and there's not an ordinance. And but it's not an ordinance thing. It's not a matter of what is there an ordinance, it's a matter of, it's, I told him, it's a condition.
What he accepted as.
Yeah, as a condition of your site plan approval. So that was the nomenclature that was used, that this was a condition of your site plan approval, not based upon an ordinance, based upon site plan approval. Okay, so everyone was very clear on that?
And that's a, it's just, if I may, that's a
Yes.
standard that pretty much every commercial developer in town complies with.
Right. Yep.
There is no borough ordinance that says it has to be a CMU block enclosure. That's typically what's called.
Right.
We do a lot of development, a lot of private development jobs, and we always put a CMU enclosure, and which stands, time barrier.
Right, and trust me, I understand his situation right now. He's basically just getting underway. To open up a restaurant in the beginning of summer, and everybody goes to the shore, I'm sure it's a hardship, but, that's between him and Mr. Mecca. Until he comes before us, and we say differently, I would.
That's what I advised him to do when he came to me, he was looking for specific orders, what the requirements were.
Yeah.
He said there's none for existing structures, most of mine's property maintenance, I advised him to go back to the board, which obviously was a condition of the site plan.
Right.
So I recommend.
So I wanted to let you know that it's between him and Mr. Mecca at this point. Yes,
It was shown on his site plan
yes,
as a CMU enclosure.
right. And he knows that. I told him.
That's what was submitted to the board, that what would be built out here
I
is
think,
CMU
I think he
enclosure.
agreed to it from the question from the board.
Was there some question about their maximum capacity or something? Was there something? It was-
On your occupant.
Yeah.
There was a number of seats we had in that case, but the number of seats you would stand. I mean, I'm sure the fire department.
There was something measured something.
I printed up the occupant loads, placards for them, just from Mr. Mecca, because he gave me the numbers, I printed them off. Just, I don't know if there's any intention of that, but those were the numbers that were furnished, so whether it was long.
I knew he brought you into the fold, so I wanted to just let you know the communication that transpired between all of us. If he has any further questions, I would defer to Mr. Mecca, and until it comes back before us, the site plan is what the site plan is. And,
Again, that's why I steered in this direction,
Right.
because most of the things that I do with are with existing structures, and that's what he was
Yeah.
looking for, to see if there was something specific, right? That's what I recommended, come tomorrow night, go before the board.
Right.
This was something. for-
yeah, I thought it was going to come inside, but I guess maybe him and Mr. Mecca came to some type of an agreement outside there as to what type of an extension he can grant him, which again, I get it. He's just getting busy now because of the summertime, it's not very busy around here in the restaurant, so hopefully that will be all good and Mr. Mecca and Dean can get that ironed out. So I thank you for speaking to him upon that, but I just wanted to let you know where we stood. You're welcome, sir. Is there any other business that the board would like to discuss before we adjourn? Entertain a motion to adjourn? All right, Mr. Dickinson, seconded by Mr. Opley. All in favor? All right. Motion approved that the meeting is adjourned at 7:55.